Uh, so we were discussing the doctrine of lifting of corporate veil, or it is also known as doctrine of पियर्सिंग ऑफ कॉर्पोरेट वेल. पियर्सिंग जो ईयर पियर्सिंग नोज पियर्सिंग आप लोग करवाते हैं, और cracking open the corporate cell, SHELL. So by 2 3 names this particular doctrine is known as, and we discussed that this doctrine is just opposite to the principle that the company is a separate personality, where the court give regard to the separate personality of the company. This concept is in contrast with that, or you can say it's just opposite of that. And so under the lifting of corporate veil is the situation where we give regard to the members and disregard the corporate entity. Okay, so the section 9 that says in our Companies Act 2013 that the company, on the date that is mentioned in its certificate of incorporation, from that date the members, or with the time the shareholders, will become a body corporate. Body corporate means separate entity, a legal personality recognized by law. And that's why it is known as that it is the creation of law, because section 9 gives that status. And then the latter part of section 9 only explain that what body corporate can do. Even if that those words had not been written there, then also it would have the same consequence. तब भी वो एक ही बात होती. Now the question is, what are the circumstances in which this doctrine of lifting of corporate veil uh, be used? And then I said it can be divided into, is the judicially recognized grounds. There are various grounds where judiciary got the opportunity to disregarding the company's separate personality and giving regard instead to the individual members of the company. The second is the statutorily recognized grounds, and there these grounds can further be divided. Statutorily recognized grounds means that the law that we have, the different statute we have, you will find a provision where the act of the company, or the crime or the offense committed by the company, or wrong act committed by the company, is actually imputed to the natural person who are in charge of that. Section 85 of the Information Technology Act 2000, where the cybercrime committed by the company, the person who is charged will be responsible. In the section 21 of the Mines and Mineral Development Act, if the violation is done by the company, again the person who is in charge will be responsible. So here, unlike the Solomon versus Solomon, it's not saying that uh, the work done by these persons on behalf of the company means the work of the company. And so these are the some situations, and the justification is that for curbing the the criminal activity, uh, it's required that mens rea has to be proved. But since company is a juridical person's artificial person creation of law, so it does not have the mens rea, because mens rea is limited only to the natural person. Second thing is, even if we, by creating the strict liability offense where mens rea has not been specifically proved, then also you can impose only the penalty upon the company, or confiscate property, etc. But the corporal punishment is not possible. You cannot put the company behind the bar. And so keeping that thing also in mind, for providing the justice, so that the concept of this separate personality would not result into the injustice. the doctrine of the corporate personality or the doctrine of the lifting of corporate veil is huge. So this statutory recognized ground can be further categorized that the provisions under the Companies Act and the provision under the other statutory. Under the other statutory, two, three example I have given: Section 85 of ITX, under Environmental Protection Act, Section 21 of Mines and Mineral Development Act 1957. Under the Companies Act, there is Section 7 Clause 5, Section 7 Clause 6, Section 12, Section 34, 35, 127, 129, 219, then 339, then 447 fraud, etc. So these are the instances. Okay. These are the in the statutorily recognized grounds. We have nothing that we have to apply our mind, because if it is written law, we have to apply it. The second or the first situation that I say, judicially recognized ground, where question arises or where question arose, that why judiciary, where the section 9 now in the Companies Act or earlier also, where it is settled position that company is a separate personality. So what forced the court to disregarding the company's separate personality, and what are or what can be those situations? So there are 5 6 grounds we have to discuss, and on those classical cases are also given. The first case we have discussed, the determination of the character of company, and here we have discussed the Daimler versus Continental Tire and Rubber, uh, Great Britain company. Okay. uh, Now, with that, I think that was the last thing we discussed in the yesterday class. Now, the second ground. But before coming to the second ground, I want to take this Ranjan Kumar, in case of fraud done by the director of the company. Yes, Ranjan, you are very right. Section 447 or sometimes student ask that or who can ask for lifting of the corporate veil? Can the company shareholder ask for lifting of corporate veil, or the other person who are dealing with the company can ask for the lifting of the corporate veil? Okay. Can the company as a plaintiff contend, or can a company in the defense also contend that lift the corporate veil and see that behind it only are the members? Or is it this ground or contention of taking the doctrine of lifting of corporate veil is available to the person other than the members of the company or other than the company? Here, the corporate veil is lifted, or the corporate veil doctrine is used in the defense proceeding. It always has to be used in the defense proceeding when the company or its shareholder, or you can say member, its company or its member, want to take the benefit that the company is a separate personality and that's why they are not liable. In that defense, like in Indian Evidence Act, section 52 to section 55, uh, about the character, good character, bad character. तो माय क्वेश्चन टू यू, ये पुराना आपका चेक भी हो जाएगा कि कितना आप लोग जानते हो एविडेंस लॉ, whether bad character is relevant in the criminal cases or not. Yes, guys, answer this question. Have you not studied the evidence law? In the Indian Evidence Act 1872, there are few sections about the relevancy of character, section 52 to 55. Lalit, Mr. Lalit Yadav, please try. Babita. Yes, Babita?
No, sir, it is not relevant.
Okay, it's not relevant because it is written there. So can you, give any justification that why this type of provision is there? भाई वो लिखा है वो तो मानेंगे ही, बट कोई जस्टिफिकेशन आप दे सकते हो? आपको लगता है इस प्रोविजन के पीछे क्या जस्टिफिकेशन है? यस अभिषेक.
सर मे आई ट्राई?
यस शुड, यू शुड.
सर मुझे सर इतना ध्यान नहीं पता सर, जब मैं एविडेंस की क्लासेस ले रहा था तो सर उसमें ये बताया गया था, जैसे मान लीजिए कभी कोई कोई रेप विक्टिम है, तो सर रेप विक्टिम ने अगर मान लीजिए कि कैरेक्टर पे अगर कैरेक्टर देखा जाए, मान लीजिए कोई ऐसा मतलब रेप से पहले कुछ दिनों पहले अगर कोई ये चीज पूछी जाए कि कोई इंटरकोर्स हुआ है, तो उस वजह से उसके कैरेक्टर को मतलब लाया जाए, मतलब एक तरीके से सर कोर्ट के सामने तो ठीक नहीं है वो, कि वो बैड कैरेक्टर था, तो इस वजह
Okay,
से
Abhishek, I got. I'm making more clear. Suppose there is person A. He is the criminal. Okay, and in the past also he committed many crimes. There are FIRs, there are the convictions also, and that shows that this person has the bad character. And in the latest trial or in the trial of some other trial, all these facts were produced that this person has the bad character. We have the proof. 17 FIR है, 4 में conviction है. But this type of all these things, नीतू is saying habitual offender में तो होता है. तो habitual offender कौन होता है नीतू?
सर लाइक कोई चोरी डकैती वगैरह जो रेगुलरली करता हो.
चोरी तो सब करते हैं. हैबिचुअल चोरी करने से थोड़ी हो जाएगा सारे.
सर लाइक मैंने एक केस देखा था.
सर्टेन
मंजीत कुछ कह रहे हैं.
certain crimes or certain moment are momentary. They have crimes are committed momentary and not intentionally. So we cannot say that the previous character is can lead to any this one.
See, you all tried very good. See, what is the principle of the cardinal principle of the criminal law? One of the cardinal principle of the criminal law is that an accused is presumed to be innocent till the date he is declared to be by the court guilty. And when the legislature or the law makes the bad character as the relevant and allows, because what the section 5 says, किसका एविडेंस दे सकते हो? जो चीज रिलेवेंट है. The evidences can be given, section 5 read with section 136 of the Indian Evidence Act. The evidences can be given of that thing that is relevant. And what is relevant? From section 6 to 55. If a particular thing you are not able to keep under any of the provisions, or if it is expressly held to be irrelevant, not relevant, then you cannot allow to give the evidence. And why it is not allowed? That was my question. If we allow, then will it not affect the mind of the judge? तो जज उसको फैक्ट्स पे डिसाइड करने की बजाय he will think, okay, ये तो habitual है, किया होगा इसने, and so that will affect our criminal justice system. Okay, so that is the justification. Manjeet, have you got my?
Yes, I have got. But this character, previous instance, can create the mindset in the judges.
See, the principle is
change,
that the burden.
They can change the mindsets.
Yes. Section 100 of the Indian Evidence Act says that the burden of proof is on the prosecution. Let the prosecution prove by independent evidences that the question that is before the court in that particular case, these are the evidences, and on those evidences, we are saying that this person has committed the crime. Why to drag all those things that he did in the past, not related to that particular case? That's the idea. Okay. But see, now there is about the good character. And interestingly, good character became relevant, isn't it? Good character is relevant. Yes, Abhishek.
सर जैसे मान लीजिए कि अब एक बैड
मानिए
कैरेक्टर है
मत, Abhishek, don't mano. Read your statute, Indian Evidence Act 1872,
नहीं
two,
सर
three
जैसे
times,
मान लीजिए
all these
किसी का
things,
बैड
and then
कैरेक्टर
file. Hmm.
है तो सर एक प्रिजम्पशन तो उसके अगेंस्ट बनाया जा ही सकता है। मान लीजिए
But
कोई
presumption,
एक गुड
if you will make the presumption, and if you are arguing like that, then what would be the reliability of your trial? And that's why, all these things coming in the media, they affect the they raise the serious doubt about the criminal justice system. 50 बार तुम अखबार सुन लो कि हेट स्पीच उसने दिया, हेट स्पीच उसने दिया, हेट स्पीच उसने दिया, फैक्ट हो या ना हो, finally you will decide कि the person who is saying gave the hate speech. I'm not saying that he did not do. This was the example I had, so I just gave. So this type of the things, like what happened in the Talwar case, Arusi Talwar case, very media trial happened.
As in the case of Kanhaiya case also.
Yes. We Indians are saying that he actually committed, but whether the facts are there or not, because our criminal justice system is not about the opinion and narrative, that has to be based on some material facts. So that's the logic. But interestingly, good character is relevant. But when a person gives the good character, then in the defense you can even argue for his bad character. The evidences can be given of bad character.
सर corroboration with other evidences तो फिर relevant हो जाएगा ना वो admissible.
Corroboration is the term we use when something is admissible and how that has to be read. So that's the corroborations. Corroborations does not allow something that has to declared not relevant or irrelevant, or is not covering under the section 6 to 55 for that thing. When you first you have to all the things that you have collected during the investigation, all the charge sheet, all the other things, all these things you have to bring before on the record. Because I was even for some time assistant district attorney, used to see all the civil and the criminal cases, have that practical thing. And then the corroboration thing is there. You at the time of appraisal of the evidences, in that respect, you discuss that whether this particular thing can corroborate this fact. Okay. So that's the thing. Now the another point I said, that interestingly good is relevant, but when the person suppose accused is saying that I have the good character, okay, and that also did, when the trial is completed, first it is on the point of what you say, one is the quantum of punishment, and before that quantum of punishment, the decision of the case. So the decision of the case is the conviction. In the conviction, another date will be given, or another hearing is on the quantum of punishment, because in the IPC, suppose for the offense it is up to the 10 year. So it's not for the every offense you have to give the 10 year. It's on the judge has to be on the facts, different fact has to decide that what punishment person can get. And in that on the quantum of the punishment hearing, all accused say that he is the sole bird earner, he has a very good character, he has all the other things, and these are things also taken into the consideration. Before that also, on the point of conviction or acquisition also, his good character can taken into consideration. But when such person giving the evidences or saying the good character, then वैसे irrelevant होगा bad character. But when the person is giving the or proving his good character, then you can show that no, you does not have the good character but bad character. तो bad character कैसे कहोगे? You have to be allowed the evidences, उन्हीं से तो दिखाओगे कि देखो ये bad character है इसका. So there it is allowed. Similar thing I want to import. I was not intended to teach here, evidence law, but similar thing that the company cannot say that नहीं जी कंपनी हमारी कोई कंपनी वंपनी नहीं है, we are just members. Company cannot contend for lifting of corporate veil. Okay, and even this thing we saw in the telco versus state of Bihar also. Okay, so company cannot contend, its member cannot contend, but other persons or the person other than the member of the company, they can contend if they found that by use of this company, either the tax evasion, either the improper conduct, either the the fraud or the other type of the illegal things is done, or you can say that by using this particular doctrine of the company as a separate personality, injustice is the result. Okay, so the corporate veil is lifted when in defense proceedings such as any liability, an entity relies on the corporate personality as a shield to cover the wrongdoers, and the shareholder cannot ask for lifting of corporate veil for their own purpose. Two cases on this you can write if you want to write. One is the Premilata Bhatia versus Union of India. Premilata Bhatia versus UOI SC 2004. I just wrote here. You have to understand. Premilata Bhatia versus Union of India, Supreme Court 2004. See, this case is not case material, just for the clarification on this particular point, that who can use the doctrine of lifting of corporate veil. Here, license was granted in the individual capacity, okay, and to the Premilata Bhatia, the Premilata Bhatia set up an wholly owned private company, okay, and she transfer that premises to that company without the government consent. Okay, and in the license it's always that without consent you cannot transfer. The license is different from lease. Even in the lease also, if section 106 of the Transfer of Property Act, you can read that. And when the government cancelled her license, then she contended that no, I have not transferred. ये तो मेरे पास ही है. And actually the company is not a separate personality, but company is only me. I was a member in the company also, and so it was not the transfer. That means he want to reckon, that means he want to use the doctrine of lifting of corporate veil to argue before the Supreme Court that see, in the company is not a separate legal personality. You have to disregard the company and see that who are the person actually behind that company, and that is me, and I have been granted the license, and the court rejected that no, you cannot take the plea as a member, as a shareholder, as a company also. You cannot take the plea adverse to what is the benefits given to you in the Companies Act. Section 9 is for the benefit of the members or for the company. It making, it's protecting this provision. Section 9 is protecting all these things. So you cannot misuse this provision, or you cannot, use the doctrine of lifting of the corporate veil for your favor. There is another case that, earlier also, while Solomon versus Solomon, we discussed the Condolly Tea Company Limited in Ray. See, generally, we have, अभी दिखा होगा आपको, मैसेज आ गया होगा. Condoli. Because we have the adversarial system, so the name of the cases will be A versus B. तो A कुछ भी हो सकता, B कुछ भी हो सकता. And in the criminal cases, it is like state versus any offender who committed the offense, and the terminology of the parties is like prosecution and defense. In the civil cases, it is plaintiff and the defendant. Plaintiff is the person who filed the plaint. But the advisory jurisdiction under Article 143 that we have, where the government can take the advisory opinion from the Supreme Court. So in that case, it's not about the two parties, like the about the appointment of the justice, the third judge case. So that was In Re Berubari Union case, where the government sought the opinion from the Supreme Court regarding the whether the government or the as an executive action, or is it required the parliamentary action to seize the territory of India. Okay, so here also Condoli Company Limited versus Condoli Company Limited In Re, it's not versus, or In Re shows that it was through the advisory opinion. I think fact certain person having joint, like 3 person having the joint tea estate, and then they form these 3 person form the company, then they transfer the joint ownership of the tea estate to the company, and their argument about the non applicability of ad valorem duty is that we three are the owner of this company here also, we three are the owner the property here also, we three are owner in the form of the company also. But other side says that you have incorporated the company, and company is a separate personality. So these three members of the company argued that no, apply the doctrine of the lifting of corporate veil and see behind this legal facade that we are three. And so it was actually not transfer, it is from us only, it is this property to us only. And court rejected the contention that the company and the members are the same person, has not allowed the doctrine of lifting of corporate veil, and said that no, this is the company is separate legal personality, you cannot contend like this, we are not allowing the doctrine of lifting of corporate veil, and so there is the liability of ad valorem duty. And so the doctrine of lifting of corporate veil invoked when the concept of personality is found to be opposed to the justice, convenience, or interest of the revenue. If the company is formed with the fraudulent purpose, with the intention of evading liability, that may be the tax liability, that may be other type of the liability, to defeat the law also. Gilford case we will discuss, where the company was formed to defeat the law, to defeating the liability of the creditors, etc. In that moment, the court can allow the lifting of corporate veil. The second ground, so this is who can ask for lifting of corporate veil. The second ground, I said that we have to start the prevention of fraud or improper conduct. When a company is formed with sole purpose, with sole intention to defeat or to circumvent the law, or to defraud the creditor, or to avoid the legal obligations that a person has bound either by the law or either by his own contract, then the doctrine of lifting of corporate veil can be allowed. Okay, here a very interesting and important classical case is there, Gilford Motor Company versus Horne. This case is in your case material at the 10th number on the page number 71. Gilford Motor Company versus Horne, 1933, 1 CH 935. Okay. Now see the facts of this case. Uh, there was a company, Ford Motor Company, and this company hired a person as the managing director, Mr. Horne. Okay. And this Gilford company was having the business in the assembled parts. Now, Mr. Horne, Edward Bert Horne, was appointed as a managing director, and like all other companies do, for the protection of their data, or for protection of their company. In the appointment of managing director Mr. Horne, there was a clause that the managing director shall not at any time, while he shall hold the office of the managing director, or after, solicit or interfere with the endeavor to entice away from any person, firm, or company who at the time, during, or at the date of determination of employment of the managing director were customer or in habit of dealing with the company. And his appointment or his tenure was for 6 years. So simply, there was the clause that we are making you the managing director. You will look after the affairs of the company, and you will come to the know many our customers, reliable customer. And so there is the covenant that during the tenure also and after that also, you will not solicit our customer. You will not solicit the person who are habitually dealing with us. So that was the covenant. What happened? This thing you can say, this type of the agreement can be made if you see the legality of this covenant. Section 27 of the Indian Contract Act. Okay. What happened after the resignation of Mr. Horne as a managing director? He has that database, पूरा कंपनी का उसके पास database था, the customer, and so directly he cannot do, because if he will start a business and start to using or alluring that thing, and company will come to know, so the company will go for the injunction. So what he did, he formed a company, एक बंदा और मिलाया उसने, और उसने एक company form कर ली, and this person opened a company. And the purpose, because for purpose, no one is telling the purpose. We have to see that for by the circumstances by which purpose he has formed. So shortly afterward, the defendant opened a business for the sale of spare parts of the Gilford vehicle in the name of the company J.M. Horne. The defendant company was just a channel, because it has only that much of the business, that much of the things. And by using all that database, by using the details of all the customer, he starts soliciting the customer. that sir होता है ना, कहीं एक बार एम्प्लॉयमेंट कर रहा हो, फिर उसका बढ़िया अच्छा रिश्ता बन जाता है, सर अब मैं तो उस कंपनी को छोड़ दिया, and I am do the second one company, and here also you can purchase this thing. And the company, this Gilford company, come to this thing knowledge. They wanted to stop this person Gilford, but stopping the person Gilford will not serve the purpose unless the court grant the injunction against the company also. But the problem is that company was not bound by that covenant. Only Mr. Horne was the managing director, and in that capacity, while he made the contract, he was bound by that covenant. See, and so there is the problem. They want, the injunction. Section 36 of the Specific Relief Act 1963 is talking about preventive relief how the preventive relief is granted. It is the discretion of the court by the injunction, temporary or the perpetual. A particular activity that affecting a person can be stopped. The injunction order can be given. Order 39, order XXIX, ऐसे लिखा जाता ना रोमन में. Order 39 of the CRPC. There also the temporary injunction. The three condition is there. Convenience of justice, etc., etc. And before the court, the issue is the whether the injunction order can be asked, guaranteed against the company JM Horne or not. Mr. Horne said that no, because company is a separate legal personality and company has not entered in any type of the covenant. Any company does not have any liability, and so company cannot be stopped for soliciting the customer. Whatever I doing is doing on the behalf of the company. Even if that is said that okay, you are not but in individual capacity also the injunction has to be guaranteed, that would also be with futile, because ultimately company unless the company is stopped, the 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 purpose would not be served. And so Gilford company contended that please lift the corporate veil and see that who are the actually person behind the company who is committing the violation of the our covenant, or who is soliciting the customer or the person who are in habitual dealing with our company. And court allowed with the reason that this company is actually formed just to avoid the application of that covenant, just to avoid the application of the law, just to circumvent that thing, just to conduct the or to just to do the improper conduct. Okay, and that improper conduct is not possible if the company had not been formed. And so as such there was no prohibition that this Mr. Horne cannot do the business. He can do the business, but only thing that what during the course of the employment he got the intellectual property, that informations he must not use for that. Okay, now there is well established the intellectual property of trade secrets. But again, we don't have the law on the trade secrets. It's only through the common law remedy that is, addressed. Okay, and so the court applied the doctrine of lifting of the corporate veil with the reason that the company was formed with the purpose of doing the improper conduct. See this case you find here on the page number 71, and please read this पैरा तो इसमें है नहीं, from page number 75, from page number 75 to 76.
Excuse me, sir.
Yes.
Sir, in our case material, it is given on page number 58.
कोई बात नहीं, 58 पे पढ़ लो. तो लास्ट के जो 2 पेज है. ओके, और पेज मीन्स 1 side. So that last side, then one before last.
Well, sir.
Side. The last of the case you will find where I'm reading from here that I certainly should not hesitate to draw that conclusion and to grant the plaintiff relief accordingly. Plaintiff, the Gilford company. I do draw a conclusion. I do hold that company was a mere cloak or sham. Have you got these lines? 5-6 lines before. लास्ट में खत्म होने से पहले की 5-6 लाइन. बबीता, मिला आप लोगों को? Okay. I do hold that the company was a mere cloak or the same, just matlab dhoka chalawa. I do hold that it is a mere device for enabling Mr. Horne to continue to commit the breach of the clause 9, and under those circumstances, the injunction must go against both the defendant, that means against Mr. Horne also, and to his company, JM Hornes also. The appeal must be allowed cost here and below, and the injunction will be in the term asked in the prayer. And so the court allowed the injunction order saying or disregarding the company's separate personality, that is company just the same, just a cloak and form only for doing the wrong act. So again, it's not you always if the situation necessitated, and with the reason, with this justification that by applying the doctrine of of the corporate veil, that improper conduct, that fraud, that avoidance of obligation can be stopped, and for the all doing all these things or applying any of the grounds that we will discuss throughout this topic, the first was for determination of character. Okay, the second we are discussing for improper conduct or the fraud. The justice always remain, the concept of the justice should always be remain in the mind. Okay, so with this this case is over. Please read this case, last के जो दो पेज हैं, please read those cases thoroughly. Okay guys, time is over. और कुछ है टाइम अभी? एक छोटा सा केस और बता देता हूँ. There is another case, and that case is also in your case material, Subra Mukherjee versus Bharat Cooking Coal Limited. This case was from the time when in the India the government was doing the nationalized activity, like the bank's nationalization case we have discussed, R.C. Cooper versus Union of India. Similarly, this case is related to nationalization of all the coal mines. But before that, there is another case that is from England, Jones versus Lipman. I'm writing in your chat box. 1962, All England Reporter, ALER. What happened in this case, that Mr. Lipman agreed to sell the certain piece of the land to Mr. Jones at a particular cost. After that, someone said that no, you are selling or you have agreed to sell this property to Mr. John at very low price. It has much value, and so Mr. Lipman changed his mind, and he have the fear also, like we have the SRA 1963 Specific Relief Act. Similarly, there also in the England, and just to avoid the specific performance of the contract, because the contract was relating to immovable property. And immovable property and movable property, the nature is very different. Mercantile things are even for that no specific performance is guaranteed. If the things is like a famous painting, etc., for the movable property also specific performance can be guaranteed by the court. But for the immovable property, it is always हो सकता है कि the plot or the flat that have the some particular location, other thing. So it's the general principle. And so Mr. Lipman has this mind that if I will intimate this person that I'm not going to transfer you, he will go to the court and ask for the specific performance. So he devised a mechanism. He just formed a small company and got registered it, and then he sold his company to his property. Then Jones come to the know, and Jones brought the action against Mr. Lipman and against her company also. The argument was given by Mr. Lipman that No, the property is no more in my hand and it is to the company. Company is a separate legal personality. And there also, court applied this doctrine of lifting of corporate veil, that your company is, you have formed your company because this company also not having any other business. That were the facts of that case. And your company is only for saving you from the specific performance of the contract, and so the court ordered the company should transfer the land to the Mr. Jones. Okay. Subra Mukherjee versus Bharat Cooking Coal Limited. This is the next case. 2003 SCC 312. Okay. Time is over. So this case we will discuss in the next class. Please read this case. It is just after the case of Gilford versus Horne, Subra Mukherjee versus Bharat Cooking Coal Limited. It is from our Supreme Court, and the case is very small. It is only in 2-3 pages. So please go through this case so that you will enjoy our coming class. With this, today class is over. If you have any question, any query, you are welcome to ask.